Picture this. You walk into a Virginia courthouse, grab your marriage license, and actually get married right there on the exact same day. No joke, there's absolutely zero waiting period. But there is a catch. If you get that piece of paper and wait past 60 days, boom, it instantly expires and becomes completely void. Welcome to This Explainer. I'm really thrilled you're joining us today. We are going to be demystifying the legal and administrative steps to officially tying the knot in the Commonwealth of Virginia. We want to completely take the stress out of the paperwork so you can just focus on the celebration. By the end of this, you're going to be totally ready to tackle the courthouse with absolute confidence. Okay, let's look at our roadmap for today. We'll start with a quick introduction, then cover eligibility requirements, the step-by-step application process, some common pitfalls you absolutely need to avoid, a few real-world examples and scenarios, and finally, wrap up with our conclusion and additional resources. Let's jump right into Section 1, Introduction, Why the License Matters. Look, I know government paperwork isn't exactly the most romantic part of wedding planning, but legally speaking, it's the most crucial step of the entire shebang. A Virginia marriage license is essentially a time-limited state mandate under Title 20 of the Code of Virginia. Now, what that actually means for you is that Virginia doesn't recognize newly created common law marriages. You can't just live together for years, share a bank account, and legally declare yourselves married. It doesn't work like that here. Without the specific official authorization from the court, the Commonwealth just doesn't legally recognize your union. This piece of paper is literally the bedrock of your legal rights as a married couple. Moving on to Section 2, Eligibility Requirements. Who can apply?
Figuring out if you're eligible is actually incredibly straightforward once you know the rules. Before you even think about heading to the clerk's office, there are a few core requirements you need to knock out. First up, both of you have to be 18 or older. Second, you both need a valid, unexpired, government-issued photo ID. We're talking a driver's license, state ID, or a passport. Don't bring an expired one because they will absolutely turn you away. Third, you need to know your social security number, or if you don't happen to have one, your Virginia DMV control number. And here is the real kicker. You both have to be there in person, together. You can't just send your partner on their lunch break, and you can't use a power of attorney. It's a package deal. You got to go together.
Now, if you're doing some late-night Googling, you might stumble across some older historical rules in Virginia Code Section 20-48, talking about emancipated minors getting a court order to marry. But scratch that, because recent 2024 legislative updates, specifically House Bill 994, make it very clear that the legal age is strictly 18. They've basically eliminated the loophole for minors to get emancipated just to get married. So no matter what some outdated blog post says, the hard and fast rule today is 18. All right, Section 3. Application process step by step. Let's turn this into an action plan. Getting your hands on that document is basically a 3-step process. Step 1, gather up those valid IDs and social security numbers we just talked about. Step 2, visit a circuit court clerk in Virginia together. And I want to really emphasize this. You can go to literally any circuit court in the state. If you live up in Fairfax, but you're having the wedding down in Charlottesville, you can grab your license at the Fairfax courthouse, or vice versa. You aren't tied to the county where the venue is located. Finally, Step 3, once you're at the counter, you'll swear a legal oath that all your info is true and you'll pay the fee. Speaking of the fee, the standard state rate is $30, but here's a pro tip to save you a headache at the counter. Definitely bring a little extra cash or your checkbook. If you decide to swipe a credit card, you'll probably get hit with a processing surcharge. Places like Arlington or Fairfax tack on a 4% convenience fee. On top of that, some localities just have slightly different base prices. Henrico County, for instance, charges $33 instead of $30. So have your main payment ready, but absolutely bring a backup and double-check their local policy beforehand. I absolutely love sharing this next fact because you can practically hear the sigh of relief from couples dealing with wedding stress. Unlike some states that still make you do medical blood tests or force a mandatory waiting period before you can actually tie the knot, Virginia requires 0 blood tests and 0 waiting periods. Literally, the second the clerk hands you that piece of paper, you can turn around and get legally married right there on the courthouse steps, if you want to. Let's move into Section 4, Common Pitfalls. Avoid these mistakes. Okay, so the application is a breeze, right? But the administrative rules surrounding the actual ceremony itself are remarkably strict. Ask yourself this absolutely critical question. Did you check your officiant's credentials? In Virginia, an officiant has to be explicitly authorized by a circuit court to perform marriages. There was this huge legal ruling called Cromer v. Commonwealth, which basically decided that ministers ordained strictly through online platforms are legally barred from performing ceremonies in Virginia. So if your best friend went online and got ordained 5 minutes ago just for your wedding, they cannot legally officiate in the Commonwealth. If they try, they could face criminal penalties, and it makes affirming your marriage a legal nightmare. Always, always make sure your officiant has active court-approved authorization. We also have to talk about deadlines because missing them is a massive deal. As a couple, you have exactly 60 days to get married from the moment that license is issued. Day 1 is the day they hand it to you. If you don't marry within that window, the license is totally void, no refunds, you just have to start the whole process over. On the flip side, once you say I do, your officiant is on the clock. They legally have to return the completed license to the issuing clerk within 5 days of the ceremony. Imagine coming back from your honeymoon and realizing your officiant forgot to mail it. If they miss this 5-day window, they can actually face legal show cause orders from the court. And this right here is exactly why you have to check your local court's specific rules. Administrative quirks vary wildly from one county clerk to the next. Take Fairfax County, for example. They are walk-in only, and if you were previously married, they demand a physical, certified copy of your divorce decree. But right next door in Arlington County, they are appointment only, and they just require a verbal oath swearing you're divorced. No physical paper needed. Down in the city of Alexandria, they allow walk-ins or even video appointments, and also rely on a verbal oath. The big takeaway? Never assume. Do your homework on your specific courthouse before you leave the house.
Next up, Section 5, Examples and Scenarios, Real-World Situations.
Let's apply all of this to some real-world situations. We've got a fantastic surprise for destination wedding planners. Let's say you're an out-of-state resident, maybe flying in from New York or Florida for a gorgeous vineyard wedding in the Shenandoah Valley. Good news, the process is completely identical for you. Whether you live in Virginia or out of state, you just apply at any Virginia Circuit Court, exactly like a local. As long as the physical ceremony takes place within Virginia's borders, you're perfectly fine. Now, what if you've been married before? Well, Virginia doesn't make you wait to remarry once your divorce is fully finalized, but you absolutely have to prove that the prior marriage ended. You need to know the exact month, day, and year of your divorce, or the exact date of your former spouse's passing. And hey, even if a county says they only need a verbal oath, the absolute best practice is to bring a certified, physical copy of your divorce decree anyway. When it comes to legal documents, it is always better to be safe than sorry.
Finally, we've made it to Section 6, Conclusion and Additional Resources after the ceremony.
We're wrapping up our tour, so let's look at what happens after the big day. Because honestly, the wedding is just step 1. After the ceremony, your officiant mails that completed license back. Once the court records it, you're going to want to request certified copies. They're usually only about $2.50 each, and I highly recommend getting at least 3 of them right off the bat. Why? Because you'll need these official sealed documents to legally change your name at the DMV, update your social security status, and get on your spouse's health insurance. Having multiple copies ready to go will save you so much administrative headache later on. Real quick, I do need to give you an essential legal disclaimer. State laws and local court regulations can and do change over time. What's completely true today might be tweaked in the next legislative session. So please always verify the current procedures directly on your specific Circuit Court Clicks website before you book an appointment or drive over there. Which brings us to our final thought. You've got the venue locked down, the rings are perfectly polished, but do you have your license? I really hope this explainer leaves you feeling motivated, fully prepared, and just completely ready to cross this crucial legal step off your to-do list. Thank you so much for hanging out and learning with me today, and a massive congratulations on your upcoming marriage.